Hello, my dear students. This is Dr. Tyagi, and today in this deliberation, we'll talk about the Employees Compensation Act 1923. As you all are aware that we are referring labor law second paper, and in this subject under unit number 4 in your syllabus, the theory of notional extension is given under the Employees Compensation Act 1923. This is video lecture number 34. See, the theory of notional extension was laid down by the Supreme Court, right, in Rashtra Salt Manufacturing Company versus Biovalu Raja, AIR 1958. So, according to this theory, in certain circumstances, an employer is liable to pay for injury to his employees even when the employee is away from the premises at the time of accident, right? So this theory of notional extension was laid down by the Supreme Court in Rashtra Salt Manufacturing Company versus Biovalu Raja, AIR 1958 SC 881. And according to this theory, in certain circumstances, an employer is liable to pay for injury to his employees even when the employee is away from the premises at the time of the accident. And in this case, it was observed that as a rule, the employment of an employee does not commence until he has reached the employment place, and he means it does not continue, right? When he has left that workplace or that employment place, then the journey to and from the place of work is thus excluded, right, from the notion of employment, right? So as a rule, the employment of an employee does not commence until he reaches to the workplace and does not continue when he has left the place of employment. And the journey to and from the place of work is excluded from the notion of the employment. This is the general thinking, right? However, it is now well settled that this is the subject to the theory of notional extension of the employer's premises, so as to include it in an area which the employee passes or repasses in going to and in leaving the actual workplace, so that there may be some reasonable extension in both time as well as in the place of work. And an employee may be regarded as in the closure of his employment even though he had not reached and or had left the actual premises where he was employed. And the facts and circumstances of each case will have to be examined carefully in order to determine whether the accident arose out and in the course of employment of an employee, or keeping in view at all times this theory of notional extension, right? So what we have gone through so far, my dear student, that as a rule, the employment of an employee does not commence until he has reached the workplace and does not continue when he has left the place of employment. This is the general rule, right? But now it is well settled that it is this is the subject to the theory of notional extension of the employer's premises, so as to include it in an area which the employee possesses. I beg your pardon. Employee not possesses. Employee passes and repasses in going to and in leaving the actual place of work. So we can say that there is no problem in detecting that the accident occurred in the course of employment when a workman is injured in the working place and in the working hour and he was doing or she was doing his duty. And the problem arises when these elements do not coincide together actually. But a workman if injured means near the premises or just before joining the work in the way to work means then problem arises. So as a rule, the employment of workman does not commence until he has reached the, as I told you, until he has reached the place of work. and means the journey to and from the place of employment being excluded, and it is not well settled. Now it is well settled. It is now well settled, however, that this is subject to the theory of the notional extension of the employer's premises, so as to include an area which the workman passes or repasses in going to and in leaving the actual place of work. And there may be a reasonable extension in both time and place, and a workman may be regarded as in the course of employment, even though he had not reached to the workplace or he had left the premises, maybe, right? So the facts and circumstances of each case will have to be examined very carefully, and in order to determine whether the accident arose and in the course of employment of a workman, keeping in view at all times this theory of notional extension. Now, my dear students, we refer a case in Weaver versus Tredegar Iron Coal Company. The House of Lords, after examining a large number of authorities, given a wider meaning of duty but did not neglected the duty test. In this case, the Lord Atkins said that there can be no doubt that the course of employment cannot be limited to the time or place of the specific work which the workman is employed to do. It does not necessarily end when the down tool signal is given or when the actual workshop where he is working is left. So means we can refer, or we can say in other words, that the employment may run on its course by its own momentum beyond the actual stopping place, and there may be some reasonable extension in both time as well as in the place, right? And in another case, in Union of India versus Mrs. Noor, a railway gangman was ordered by his employer to go to another place for cleaning, and in the way from one place to another, this accident happened, right? And Justice Shukla observed that the accident has occurred in the duty hour, and when this employee was going to do or to perform his duties, right, on behalf of the employer. And in this case, Honorable Justice Shukla concluded that the accident has occurred in the course of his employment. So there are some situations where this doctrine does not apply. When a workman is on the public road or a public place and not there, are fulfilling the obligation of his work, does not mean necessary to be there. But the proximity of the work premises or the spot of accident become immaterial. The notional extension of the place of work case cease when workmen come to the public road. There were some clarifications made in case in this matter. So we can take another case. So Rashtra Salt Manufacturing Company versus, as I told you, that it is well settled that when a workman is on the public road or public place or on a public transport, he is there as any other member of the public and is not there in the course of his employment unless the very nature of his employment makes it necessary. So of course, we have to look into the matter, and it varies from situation to situation, that in the course of his employment, unless the very nature of his employment makes it necessary for him to be there, then only we will say that yes, it is in the course of employment. And a workman is not in the course of his employment from the moment he leaves his home and he is on his way to his work. He certainly is in the course of his employment. If he reaches the place of work or a point or an area which comes within the theory of notional extension, outside of which the employer is not liable to pay compensation for any accident happening to him. So that we have to observe carefully. So as a rule, as we have discussed, the employment of an employee does not commence until he has reached the place of employment and does not continue when he has left the place of employment, right? But the journey to and from the place of work, journey to and from the place of work is thus excluded from the theory of notional extension of the employer premises, and so as to include it in an area where which the employee passes and repasses in going to and in leaving the actual place of work. so that there may be some reasonable extension in both time and place, right? So place of work, so that there may be some reasonable extension, right? And an employee may be regarded as in the course of his employment, even though he had not reached or he had left the actual premises where he was, employed. So the facts and circumstances of each case will have to be examined carefully. So we need to focus on the circumstances, right? And whether the accident arose out of and in the course of employment of an employee, keeping in view at all times this theory of notional extension, right? So this is all for today's deliberation, my dear students. Please go through these PPTs, these slides will definitely help you, right? Thank you so much. Have a nice day. Have a nice time. Take care.